Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. Rebecca Scofield has filed a memorandum in opposition to defendant's motion for continuance. We had previously reported to you that last week the defense filed a motion seeking to continue the trial, which is currently scheduled to occur a week from Tuesday, 4-day period commencing the 24th of February in a federal courtroom in Boise, Idaho. Now, what the plaintiff Scofield is stating here is that she's pointing out defendant Ashley Guillard asks the court to continue the trial that has been set to begin a mere 18 days after she filed her motion. She does so, according to the plaintiff, ladies and gentlemen, on the grounds that she needs time to prepare for a trial set 6 months earlier, on the grounds that she needs more time to prepare to examine a witness she has known about for more than 2 years, and on the grounds that she mistakenly filed her, and then in parentheses, meritless, third motion to dismiss for subject matter jurisdiction later than required. This court, the plaintiff continues, ladies and gentlemen, should reject Ms. Guillard's last-ditch attempt to further delay these proceedings. Professor Scofield brought her claims more than 3 years earlier, and she cites to ECF, which is document number 1 here. She has withstood Ms. Guillard's repeated attempts to delay the proceedings through repetitive motions to dismiss, motions to reassign this case, motions to reconsider rulings, and other pleadings lacking merit. On August 12, 2025, this court entered an order setting trial for February 24, 2026, and she points here to ECF number 100. That's document number 100. Ladies and gentlemen, on the court docket, concluding here in the introduction section with no grounds exist to continue that trial, particularly at this late stage. So it appears what the plaintiff is arguing here is it's a little bit too little, a little bit too late. There's no merit, according to plaintiff, to any of the arguments for a continuance of the trial. And by the way, it's very late in the game, according to plaintiff, to do this. This case, as she has noted, has been pending for more than 3 years. The case was filed in federal court back on December 21st, 2022. That was even earlier than Brian C. Koberger's arrest in the criminal case styled as Idaho versus Koberger. Mr. Koberger wasn't arrested until December 30th, 2022, to give you some indication of the timeline here. And what this case is about is it's a 2-count complaint brought by a professor of the University of Idaho, Scofield, against Ms. Guillard, who has been described in the pleadings and the motions and the court documents as being an online personality, a content creator, and a psychic. Count 1 is that plaintiff states she was defamed when the defense allegedly stated that she had responsibility for the catastrophic events that occurred at 1122 King Road on November 13th, 2022, and count 2 for defamation alleges that she was further defamed by public statements that she had been involved in a romantic relationship with one of the students. The plaintiff has vigorously denied these allegations. The defense has just as vigorously denied that she defamed the plaintiff. The plaintiff here in this multiple-page motion is concluding by stating Ms. Guillard has employed a variety of delay tactics throughout this litigation. It is time for them to end. The court should deny Ms. Guillard's motion to continue, and the trial should proceed as scheduled on February 24th. And this is signed by counsel for the plaintiff, Wendy J. Olson of Stoll Reeves. This is the law firm that you may recall if you followed the Idaho versus Koberger case that represented the media coalition in the criminal proceeding. Ms. Olson made several appearances in the case, the last being in July when she successfully urged Judge Stephen J. Hippler to set aside the non-dissemination, aka gag order, after Mr. Koberger pled guilty. We are awaiting a reply, which the defense will have the opportunity to submit per the court order that the judge put into effect. She has until this Friday to file the reply, which would reply to this response. One last time that she has the final say here, arguing why this continuance should be granted. Will this case go to trial as scheduled on the 24th, or will the plaintiff win this continuation of the trial? That will be the answer that the trial court will determine after the briefings are all in. Until next time, this is Kathy. Thank you for joining us here today.